to everyone. This is our second day of our interaction on the law related to cyberspace. Before I start today's interaction, let me remind you what we did yesterday. We started with introduction to cyberspace, where we talked about how this term came into picture and how since then this has become so popular. After this, we came down to second aspect, second heading, second major point, that was emergence of cyberspace. Here we talked about history of computers to some extent, and talked about how this internet developed, how it was invented, where it was invented, and in the light of major inventions, how it got global. Here we talked about certain important inventions like TCP/IP, which made computer networking easier. We talked about DNS, which made classification of database easier. And we came down to WWW, the most important development, World Wide Web, which gave it the character, which gave it the real meaning, which we all understand. The way we all have used internet, the way we all have experienced internet, that started with the invention of World Wide Web. We talked about this. We also talked about, we came down to this fact that today the reality is that this is considered to be the mother of all revolutions. We often compare it with the great revolutions of the past, like the invention of printing press, invention of sailor's meter. Today, the condition is, today the situation is that the critical infrastructures we have, the critical infrastructures of every country, they have become dependent on cyberspace. This is the level at which this space, this technology has expanded itself. And today it won't be wrong if I say that everything on this, everything around us has become dependent on this cyberspace. And that is why there is so much, it holds so much importance. And the bottom line here was that today we are living in an era where we have open, linked, we have a network which has covered almost every developmental activity around us, whether it is power sector, whether it is defense sector, whether it is industries, whatever you name, whatever you go for, whatever sector you name, the thing is that has totally become dependent on this. This is the pace at which it has grown. Then one more thing which I highlighted yesterday, that was that this cyberspace. When you talk about cyberspace, the most fundamental thing about, the most fundamental understanding about cyberspace is that it is an extension of physical world into an indefinite space. I repeat what I said. It is an extension of physical world into indefinite space. So as we have rules, as we have certain rules, certain regulations, certain laws, certain legislation, certain guidelines, certain standards, certain frames for physical world, the same thing we require for the same set of things we require for this medium also, this space also, which is an extension of the physical world. So when we have rules, when we have regulations for the physical world, the same set of the requirements, the same set of standards are required for something which is an extension of the same thing. And that is why this links us to the third point which we talked about yesterday, that was the regulation of cyberspace, our main concern. Regulation of cyberspace. Under this, we talked about what were the factors that led to the regulation of cyberspace. And here in short, I told you that here UN played a very important role. A specialized agency established under UN which we talked about, UN Settle played very important role, and especially after WWW, World Wide Web, when the internet went for commercial use. Internet's commercialization started after invention of World Wide Web. Commercialization की वजह से again always remember wherever where when commerce creeps in, when commerce enters, there are conflicts. All right, so one thing is there, and when the world shifted for its commercial use, the thing was, I gave you example also, the startups like Amazon, the startups like eBay coming up in 94, 95, and mid 90s, the situation was that the contention of that point of time, the conflict of that point of time was whether we were having adequate rules, adequate laws to deal, to provide legal sanctity to online transactions, to online invoices. We were shifting for online transactions. So here UN Settle came up with UN Settle model law on e-commerce in the year 1996. It was passing a resolution. It was adopted by UN General Assembly in the year 1997, and then a circular was sent to every member country. India being a founder member country, we also received that circular, and in that circular it was written whether if you have any such law, then you reframe it, redesign it, reenact it in the light of UN Settle model on e-commerce. And if you don't have any such law, any such framework, any such arrangement, then you come up with a new one. Then you design a new one. Then you frame a new one in the light of UN Settle model on e-commerce. And the onus was on the then government, and the IT bill was accordingly prepared. IT bill getting passed in both the houses, receiving assent of the president, it became the IT Act, which is applicable since 2000. About this, we also talked about certain facts, like when IT Act was enacted, four acts were amended. First was IPC in the wake of new kind of crimes. Second was Indian Evidence Act to take into consideration the new form of evidences. Then Bankers Book Evidence Act, again issue related to banking because it was very much related to e-commerce. And fourth was RBI Act, and again to give legal sanctity to new kind of transfers, to new kind of money transfers, banking transactions, online banking transactions. Apart from this, we also talked about that under IT Act, we have 13 chapters, we have 90 sections. And if you go by the Bare Act, if you go through the sections, the thing is, if you go through the introduction to the Bare Act, we find that it is mentioned that initially it was enacted, it was framed with two broad objectives, two main objectives. First was to promote e-commerce in the country. It was but obvious because it was based on UN Settle model on e-commerce. So one thing had to be promotion of e-commerce, and second thing was to promote e-governance in the country. About e-commerce, what I told you was that there were certain requirements, and for again like authenticity of sender, message integrity, non-repudiation, and for this, I told you that always the world has relied on encryption. So the cryptography, which is there, it is one of the encryption technique. And the most popular thing here is, the popular tool here is the digital signature certificates, which I mentioned yesterday. When we buy, we require for different in different sectors. Like if we have to be a director of our company, we need to have a digital signature certificate. If we want to file ITR, online ITR, then again one of the criteria is we can use our digital signature. So again, when we go for that, we have to approach certifying authorities, and when we buy that, the person on whose name digital signature certificate is issued, that he is called subscriber. So this is some most important development related to e-commerce. Then the second focus was on e-governance. Regarding e-governance, let me always keep this in mind that the delivery of services by the government, the delivery of services that is done from the government side to the public, for the public, when it is done using ICT, using information communication technology, then it comes under the purview of e-governance. And regarding e-governance, we have a dedicated chapter, that is chapter 3 of the IT Act, where we have section 4 to section 10A, where they have covered different aspects that promoted that aim at promoting, developing, promoting e-governance in the country. We have lots of e-governance projects, successful e-governance projects at every level, whether at central, state, or district level. And again, the most important one is the IRCTC, then your E-Mandi Bhav. There are many such programs. Though though region-wise, it may be more successful, it may be less popular, but again, the thing is, every government today, the thing is, they have gone for e-governance. And today, the reality is, friends, that we are living in an era where we have the mobile governance, where even government department, they have come up with their apps, and again they are providing different services. So this was our third focus, third point. And then we came to the fourth point, that was the initial challenges. Initial challenges, let me tell you that first of all, we started with when we came up with our own cyber law, we came up with our own cyber regulation, IT Act. The initial challenge was that how to fix jurisdiction. And regarding this, let me tell you, the sections we have under IT Act that have enough, that provide enough scope to exercise jurisdiction. And there was when the judiciary was finding it difficult, when the courts are finding it difficult to determine that whether to apply jurisdiction or not, then let me tell you, the practice was that we have, India, like all other countries, they have always used the theories, the tests, which were initiated by, which were developed by US. There is a reason why it is in this manner, because it was US which came up with this internet thing. Internet was their brainchild, and it was US which for the very first time confronted these disputes, cyber disputes. So it was US which for the very first time came up with certain theories, certain tests, certain standards, using which jurisdiction could be applied. And about jurisdiction, let me tell you, it is one of the most important element of administration of justice. If we have to promote rule of law, if we have to promote administration of justice, delivery of justice, again, one of the essential criteria is, one of the essential thing is that the jurisdiction must be proper. And regarding this, we have different different we have enough theories, enough tests, like effect test. किसी भी बात का, किसी भी issue का again effect देखा जाता है, where according to the effect jurisdiction can be exercised. And again, target also, it is seen during arguments, it is said that what was the target. And yesterday also I was giving you an example wherein during this uh, farmer agitation, when there was a girl from abroad, the comments of whom were targeting India, and again, taking that into consideration, a case was filed against her. And again, in this situation, the jurisdiction was proper. So this was the thing that was handled in this manner. Today, the thing is, though we have different other challenges, but exercising jurisdiction is something which we can have under the IT Act. Then another initial challenge was related to the concept of a digital signature. The digital signature was something obsolete, and for this, we came up with when the 2008 amendment took place. We introduced the concept of electronic signature. This is a broader concept, and it includes under its purview everything. So under the concept of electronic signature, we have digital signatures, we have the name written after the mail, when we mail someone, when we write our name, that comes under the category of that comes under the definition of electronic signature. Then when we write, when we sign on a piece of paper, scan it, and again send somewhere, that is also our electronic signature. Then our biometric, that is also our electronic signature. And today the thing is that modes may change, but again we don't need no there is no requirement of any kind of amendment which was required under digital signature concept, because digital signature was narrow in scope and this one is broader in scope. So this was done. This limitation was over with the change that was made after Amendment Act of 2008, which was incorporated, which was implemented in 2009. After this, we also talked about Section 6A. Section 6A was, again, I told you that e-governance, again, a very important thing. And every time, many a times, the government, they don't have expertise, they don't have money, they don't have the knowledge. And again, what they do is they rope in private players. And again, this partnership which can be developed, that has been given legal sanctity by Section 6A. Section 6A falls under the Chapter 3, which deals with e-governance. So Section 6A makes this possible, provides legal sanctity to this kind of partnership between private players and public and the government departments. So I gave you example that the Aadhaar card thing, when Aadhaar cards were being issued, again there was no one from the side of the government; all were private players, and this kind of partnership has been the legal sanctity is provided by the Section 6A under the IT Act. Now let me just give me a minute. Let me share the PPT again, and in the light of that, with that I would be taking the this discussion further. Is it visible?
Yes, sir.
All right. So we were till this section 6A. Now we would be focusing on certain other aspects, which were again the initial things. Uh, in this regard, let me again remind you that there were two main objectives: e-commerce and e-governance. And one thing more which you have to always remember is that after 2008 Amendment Act, uh, which was implemented in 2009, practically the third focus came up, entered the scenario, and this was to take care of e-crimes. So practically since 2009, we have three main objectives. First, to promote e-commerce in the country. Second, to promote e-governance in the country. And third one is to tackle e-crimes in the country. Now coming to the cybercrime thing. Cybercrime is again a very important thing that is related to cyber regulation. So we need to have an understanding about this and what we cover under this. So here, let me tell you that the cybercrime, it includes crimes which are committed through use of computers or where uh, the computer or computer network is the target of crime. And again, going by the NCRB data, again the number is increasing year after year. And in 2009, we just had 420 cases, and now the number has skyrocketed. And the most Uh, Disturbing thing here is that earlier it affected affluent, now it is affecting everyone. There are reasons behind it, that why everyone is becoming prey to the cyber criminals. The thing is, earlier the internet was the user base of internet was too less. All right. So now the thing is, as it is getting popular, as the user base is expanding, as the prices are going down, again the thing is that that everyone is now becoming a victim of cybercrime. So in this wake, in this 2008, again the most of the changes were made, most of the amendments which were made, which were made in the 2008 amendment to the IT Act, that were related to e-crimes. All right, so we have a chapter 11 that deals with offenses. So most of the changes are related to chapter 11, that is the offenses. About cyber crimes, let me tell you that there is a certain classification. The first classification is the conventional crimes through computer. So these are those crimes which were existing earlier, but now they are being committed using computers, like cyber defamation. The defamation, again, defamatory speech and defamatory comments, again they were there, but now the thing is, it has changed its scope. Now we have this in the form of cyber defamation. And again, the anonymity, which people think that they are anonymous, no one can know, no one can know that who are they. Their identity uh, could not be known to anyone. So because of this, cyber defamation cases have increased. And again, the difficulty here is that if someone is victim of this, his reputation is injured, and due to the global access, due to the global outreach of internet, again, someone who is not mentally strong, uh, they, 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 they are in a vulnerable position. So again, for this, we have sections under IPC as well as under the section IT, section under the IT Act. Again, we have a issue regarding the section 66A. Then we have these kind of cases related to cyber defamation. Then we have digital forgery. Forgery also was used to take place earlier also. Now the thing is that computers are used as tools, computers are used as targets. Again, example are fake entry passes, I cards. Again, here also, so digital forgery is also a kind of crime which has again gone up. Then we have cyber pornography, again something which has always existed in the form of literature, in the form of sculpture, in the form of drawings. But with a change in the technology, again, the sharing of such content, the dissemination of such content has also gone up. So during the with the different invention of modern cameras, then computers, then internet, again the porn content that has also gone up. And this issue is also dealt under this IT Act. And again, we have different sections: section 67, section 67A, and 67B. And regarding this, let me tell you what is the judicial stand in this regard. Many a times the Supreme Court has come up and very like they have been very particular about these kind of content. But again, there were mixed responses. Some of them supported the stand taken by the Supreme Court, but some groups, they were against the stand taken by the Supreme Court, where it called for a complete ban on such sites. And those who were opposing it, their view was that again, actually the thing was that here the history was here the issue was that and this Nirbhaya incident, unfortunate incident, one of the perpetrator, one of the culprit, he accessed his porn content before committing that crime. So a PIL was filed, and in that it was said that this kind of content is promoting the sexual assault in the society against women. So it was in this light the Supreme Court came up with that the government should take steps to completely ban these kind of content. But again, those who opposed it, their view was that this is the judiciary has no right to peep into one's private affair, and this is their decision. And again, and it was taken down. But one thing is there one good development regarding pornography has been that when it comes though there is no consensus regarding general pornography, but when it comes to child pornography, again there is no society, there is no nation in the whole world which doesn't wants to curb that. So everyone supports the point that the child pornography must be completely banned, and maximum efforts which have been taken place and which are taking place regarding pornography, they are related to the child pornography, for which we have section 67B of the IT Act. So this is there. Then cyber stalking is there, harassment. Again, many a times due to different reasons, this has taken place. And again, these kind of issues, wherever there are breakups, we have seen people cyber stalking each other. And again, this is the kind of harassment. And again, there are a number of cases regarding this. Then we have another set of crimes under cyber crimes, like the cyber crimes committed on a computer network, financial frauds, like hacking, unauthorized access is there. Then we have denial of service, where again, if it is if someone if a computer or if someone's office or if someone's computer if someone's attacked the computer, a functioning the functioning of that office is it disturbs, it is disturbed. And again, if it is from one computer, it is denial of service, and if it is the attack is made from more than one computer, so it is a distributed denial of service. So again, this is something taken to be a cyber crime. Then we have email spamming, email bombing is there. Again, when you send someone 10,000, 20,000 mails one fine morning, so you can disturb his whole his day. And this kind of disruption is taken to be a cyber crime under the IT Act. Then we have email spoofing. You don't know, this is the kind of cheating and forgery. And again, you receive a mail and thinking that this is your friend or this is your relative. Again, you reply. Again, you reply on that mail, and again, many a times we become victim of email spoofing if we are not technically sound enough to know whether that was a original ID or not. Then we have data theft. Again, this is a kind of a cheating that is taking place. Then we have cyber terrorism, a very serious thing, and which is again section 66F IT Act. And again, it was in the light of this that the amendment took place, and this was particularly the Mumbai attack. And because to insert cyber terrorism under section 66F IT Act, the change was made to the IT Act. Then we are spreading virus, worms. Again, that is considered to be a public nuisance. And again, these are some technical aspects, technical tools using which someone's office or someone's computer network can be disturbed. So this is again taken to be a public nuisance. Then we have phishing. You receive a mail, you receive a message, and again that someone is calling from someone is from your bank or from your insurance company, and again they try to fool you. So then we have identity theft. Then we have email frauds, lottery scams, and then we have credit card frauds, cheating and forgery. And then we have web jacking, where again the whole website is taken into control. And again, extortion money is they demand extortion for that. And again, the thing is that nowadays they are asking for 20,000 to 50,000 rupees. And again, if your data is of if is worth 2 lakh or 5 lakh, again paying 20,000, and no one even reports to the police. So this is the thing. Again, this is getting popular these days, web checking. Then we have electronic signature, and again, many a times we if we have purchased just a certificate, digital signature certificate, uh, for us, say for 1 year, and beyond, so we can use that till that point of time only. If beyond that, if we use that, if we fix that, or again, if we give a if we give a false impression that we have the signature, and again using that, if we try to influence someone, then that is also taken to be a cybercrime. Now coming to, so this was the thing. So regarding cyber crimes, the initial challenges which were there, what I wanted to tell, what I wanted to share was that the amendment that was made in 2008, which was incorporated, which was inserted in, which was implemented in 2009. So the e-crimes, there was a focus on e-crimes. Then there was one more initial challenge that was related to the whole regulation of cyberspace. And here this was related to the intermediaries. So this is again one of the initial challenge. Before we come to the current thing, we need to be clear with one more and most important initial challenge, and this was related to intermediaries. About intermediaries, let me tell you that in any scenario, in every scenario related to cyber, in everything that is related to cyberspace, there are always three entities. On one end we have the originator, on the other end we have the addressee, and between these two we always have intermediary. Between these two always we have intermediary. Originator uh, is someone who comes up with a message, who comes up with something. Addressee is the person who is intended to receive that message, and this connection between originator and the addressee is made possible because of the intermediary. This was another initial challenge related to cyber regulation. Please be clear with this fact, because this will help you in understanding lots of future developments. This is something which is related to every aspect of cyber regulation. I repeat, initially there was an issue related to intermediary. To understand that, we need to be clear with the scenario. The scenario in every cyber situation is we have three entities. On one end, we have the originator, which you are finding here. On the other end, we have the addressee. And between these two, we have an intermediary who makes this connection possible. Regarding this, in the initial stage, 2000 to 2008, let me tell you that the term intermediary was narrowly defined. When I'm saying narrowly defined, the limited provisions, we had limited provisions, and they provided little to no protection to online intermediary. To understand this, we would be taking this case study of Bazi.com. Bazi.com was an Indian subsidiary of eBay. Here, what happened was it was related to a DPS scandal that happened. That became very popular. A student of DPS, he made a video of his girlfriend, and that video was viral. One student, a fourth year student of IIT Kharagpur, he what he did, he posted this clip, this MMS clip, on this site Bazi.com, Indian subsidiary of eBay. All right. So he posted this, and again, this he posted that on Saturday evening, and it remained there till Monday morning, around 10 to 11, where, uh, when it was like till it was there. Till Monday it was there before it was taken down by the Bazi.com team. No one came to know about this, and again during this time period there were 8 transactions, and again one had to pay 28 rupees for that. So 25 rupees was he had to get the fourth year student, and the 3 rupees was a commission of Bhazi.com. Again, something a business operandi which we all understand. They provide us the platform, we post our goods, and again they receive their commission, and again we get the cost what we want, and if someone is ready to pay for that. So this happened. No one came to know about this. After a few months, there was a breaking news. Breaking news was that there is the cyber crime has been unearthed, and again this is a first time in India, and this and that, whatever we all understand how they highlight these kind of news. As a result, as a result of this, the CEO of Bazi.com, this gentleman which you are seeing here, Mr. Avnish Bajaj, the CEO of Bazi.com, he was arrested. Along with him, Mr. Ravi Raj, the fourth year student of IIT Kharagpur, they both were arrested and charged with the same offense. There is a reason why I'm calling him a gentleman, because he was a Silicon Valley product, and Silicon Valley has always ruled the software world of India. And this gentleman, who was from Silicon Valley, he was lodged in New Delhi's infamous Tihar jail for 4 days, along with about 70 other prisoners accused of crimes ranging from pickpocketing and rape to murder. And he was here for 4 days, and again it was very disturbing. And again, his contention was the contention of the whole team of Bazi.com was that what was their fault? Is it possible for them to look into each and every post which is made? And when they received the complaint, they took it down. This was their plea that they took it down on on Monday morning. So why are they responsible? Say if there were 8 transactions, so what they got? What Buzzy.com got? 8 into 3, 24 rupees. For 24 rupees, you have arrested Mr. Avnish Bajaj. You have lodged him in the Tihar jail for 4 days for this too less amount. It highlighted the lacuna in law. So this was a big lacuna at that time in our cyber law, in our cyber regulation, and whereby an intermediary could be held to liable, because these intermediaries, this is the intermediaries which makes the connection between the originator and the addressee possible. So accordingly, the IT Amendment Act 2008, it introduced that they would be providing a level playing field to the intermediaries. They requested that on one hand you want startups like us. If people like Avnish Bajaj would be arrested, no one will dare to enter the Indian market. And again, Nescom is using the platform of Nescom. They started creating pressure on the government, and government came up with this Amendment Act, where efforts were made to provide them a level playing field, broaden the scope of safe harbor protection available to intermediaries. So safe harbor provisions were introduced, and again, protection. The efforts are made to give them the protection if they abide by the rules. So to understand this, let me take to the stage two. That is a post IT Amendment Act 2008. What happened was the definition was broadened. The definition of intermediaries that is given under section 21W, that was broadened, and the changes were made under section 79 of the IT Act. The chapter 12 deals with intermediaries. Under chapter 12, we have only one section, section 79, and section 79, under section 79, changes were made. Intermediary की definition के बारे अगर मैं आपसे share करूं तो this was broadened, and again whether this explains intermediary as any person who on behalf of another person receives, stores or transmits that record or provides any service with respect to that record, and These are the 9 entities. These are the 9 entities which are mentioned, under section 21W. So we have ISPs, we have TSPs, we have NSPs, we have WHSPs, we have online auction sites, we have online payment sites, we have online marketplaces, we have cyber cafes, we have search engines. And today the things have become more complex. बिकॉज जो पहले आईएसपी थे वो आज टीएसपी भी हो गए हैं, वही आज एनएसपी भी हो गए हैं, वही आज डब्ल्यूएचएसपी भी हो गए हैं, वही ऑनलाइन पेमेंट साइट भी हो गई है, वही हमारे सर्च इंजन हो गए हैं. So the things have become more complex. In other words, intermediaries have become more important. All right, they have become more important. And again, one thing always remember, always stick to this point, that if we want to regulate cyberspace, that cannot be done without regulating intermediaries. एक और तरीके से हम इस चीज को समझ सकते हैं कि रेगुलेशन ऑफ साइबर स्पेस, under regulation of cyberspace, actually in real terms, practically what we have is the regulation of intermediaries. इंटरमीडियरीज को आप रेगुलेट करेंगे तभी आप साइबर स्पेस को रेगुलेट कर सकते हैं, बिकॉज इंटरमीडियरीज आर द सोल, इंटरमीडियरीज आर द बैकबोन, इंटरमीडियरीज आर द एवरीथिंग इन द इंटरनेट. So they have to be controlled. On if we are not in a position, if अगर हमारे लॉज, अगर हमारे गाइडलाइंस इतने इफेक्टिव नहीं हैं, इतने एडिक्वेट नहीं हैं, इतने एफिशिएंट नहीं हैं कि हम इंटरमीडियरीज पे नकेल रख सकें, उनको हम उनको कंट्रोल कर सकें, तो अगेन वी कैन नॉट हैव एनी काइंड ऑफ रेगुलेशन ऑन साइबर स्पेस. तो इसके लिए इनको कंट्रोल करने के लिए ड्यू डिलिजेंस was introduced, and this was in the form of the IT Intermediary Guidelines Rules 2011. 2011 में the central government came up with these rules. Under this we had Rule 3 which talked about the due diligence. इसमें बहुत अच्छी चीजें लिखी हुई थी. एंड दिस वाज कि एक्चुअली हम लोग जब कोई भी एप्लीकेशन यूज करते हैं, हम लोग जब कोई भी वेबसाइट यूज करते हैं, तो बेसिकली हम उनका कंप्यूटर रिसोर्स यूज करते हैं. एग्जांपल मैं देता हूँ आपको. अगर हम लोग फॉर एग्जांपल हम लोग इस गूगल मीट से हम आज ये इंटरेक्शन पॉसिबल हो पा रहा है, तो एक्चुअली वी ऑल इन दिस इंटरेक्शन वी आर यूजिंग द कंप्यूटर रिसोर्स ऑफ द गूगल. इसी तरीके से ये फेसबुक है या और भी जितने भी एप्लीकेशंस हैं, when we use those applications, actually we are using their computer resource. And the intermediaries के लिए ये चीज जरूरी बना दी गई कि they would be publishing the rules, regulations, privacy policy, user agreement. If you want to use a computer resource, then you have to, if you want to be facilitated from our side, then you have to follow certain guidelines. So such regulations, such rules, regulations जो है कि you will not host, you will not display, you will not upload, modify, publish, update, share any information that belongs to another person. You will not do anything that is grossly harmful. You will not do anything that is harassing, blasphemous, defamatory, obscene, pornographic, pedophilic, invasive of another's privacy, hateful. Then you will not do anything that may harm others in any way, that may infringe someone's intellectual property rights, that may violate any law for the time being in force, that may addressy about the origin of such messages. You will not do anything which may impersonate another person. You will not do anything that will contain software viruses. You will not do anything where you can destroy, interrupt, or limit the functionality of any computer resource. You will not do anything that threatens the unity, integrity, defense, security, or sovereignty of India, friendly relations with foreign states, or public order, or causes incitement to the commission of any cognizable offense, or prevents investigation of any offense, or is insulting any other nation. Meaning by this is something which would be told to them. Apart from this, intermediaries को ये भी बोला गया कि अगर इसके अलावा अगर आपको हम सूचना देते हैं तो विद इन 36 आवर्स आप जो है you will start taking action. And at least 90 days के लिए आप इन्वेस्टिगेशन पर्पस के लिए वो जो एसोसिएटेड रिकॉर्ड्स हैं, जो इंफॉर्मेशन है, you will retain that. इसके अलावा the information or whatever assistance is required by the legal enforcement agencies, you would be providing this. Let me repeat you, we are going through due diligence, we are going through the IT guidelines, rules 2011, which were there to protect, which were there to exempt liability, exempt intermediaries from any kind of liability. Or in order to exempt from any kind of liability, they have to make sure that they inform they inform their users that they would not be doing anything that is provided under this, and the intermediaries would be providing the full support to the legal enforcement agencies. Now इस यहाँ पर एक चीज और, द इंटरमीडियरी shall take all reasonable measures, and जो हमारा जो sensitive personal data होता है, they would be taking care of that. Sensitive personal data के लिए एक और rules हैं, again we need to understand. Please be clear with this. We have reasonable security practices and procedures and sensitive personal information rules. Under this, हमारा पासवर्ड, हमारी फाइनेंशियल इंफॉर्मेशन like बैंक अकाउंट, क्रेडिट कार्ड, डेबिट कार्ड, पेमेंट इंस्ट्रूमेंट्स, physical, physiological, mental health condition, sexual orientation, our medical records, history, biometric information, any detail relating to above clauses, again which we is required, which we have to give to the body corporate for providing services. Again, this comes under the category of sensitive personal information. और अगर इनको exempt होना है from any kind of liability, then they would not be sharing sensitive personal information of anyone to a third person without taking a permission. So this is there. Apart from this, एक चीज और थी, the intermediary would be publishing on their website the name of the grievance officer, और उसकी कॉन्टैक्ट डिटेल्स देंगे, और ग्रीवेंस ऑफिसर पे भी एक ऑब्लिगेशन होगा कि ही would be redressing the complaint if a complaint has been filed within 1 month from the date of receipt of complaint. So grievance redressal जो है, that was the obligation was within 1 month they have to do so. The grievance officer, भाई हमें अगर कोई इशू है फेसबुक के साथ, तो अगेन वी नीड टू हैव द नेम ऑफ द ग्रीवेंस ऑफिसर ताकि हम उससे कांटेक्ट कर सकें. And again, if a issue has been reported, then that complaint has to be redressed within 1 month from the date of receipt of the complaint. So this is the mechanism which was developed in 2011. और ड्यू डिलिजेंस की अगर हम बात करें तो it talks about taking down the illegal content, providing user information for investigation to legal enforcement agencies, report cyber security incidents, report to the National Cyber Crime Portal. सर्टिन एक है कंप्यूटर इमरजेंसी रिस्पॉन्स टीम ऑफ इंडिया, यहाँ पर भी इनको बताना होता है, डेटा प्राइवेसी का ध्यान देना होता है, सेंसिटिव पर्सनल डेटा से रिलेटेड इशू है, एंड अपॉइंटमेंट ऑफ ग्रीवेंस ऑफिसर. But these are the developments. These were what we had in the black letter. But now coming to the practical thing, now coming to the practical aspect, and here let me tell you that though we were having this, these provisions, though we were having 2011 guidelines, rules, though we were having the broad definition of intermediaries, all right, everything was there, and it was made very clear that under what circumstances the intermediaries would be exempted. Everything was clear. But in 2018, around 2018, let me tell you, last 2017 and 2017, 2018, around that time period, around that point of time, there were lots of mob lynching cases. There were lots of mob lynching cases which were reported across India. All right. Sometime on some cases UP, some cases from Northeast, some from Maharashtra. There are lots of cases, more than dozen cases, and related to mob lynching. And when it was reported in the newspaper, when it was analyzed, it was seen that uh, in most of the cases, in most of those unfortunate incidents, uh, the the issue started from the fake news or the rumor, false information. So further analysis was done, and further analysis further analysis, the analysts, those who were working in this regard, they came down to the fact that in maximum, in almost every such incident, uh, the platform which was used was WhatsApp. So they came down to the fact that WhatsApp was being used. About WhatsApp, let me tell you one thing. Whatever we have related to social media, whatever we have issues related to social media, the social media, again, the way it has expanded, the way user base has expanded of social media. If we talk about WhatsApp, WhatsApp, it would have, or it already would have, or it would be touching um, very, you can say, very soon, the mark of 50 crore. 50 crore user base in India. My point is that user base wise, these social media platforms, they have expanded so much that they are bigger than lots of countries. This is the level at which they have expanded. And here, what I want to highlight is that around 2018, in the mob lynching cases, in almost every case, the cause of action, or the reason was the fake news, the fake information, the rumor, and that was shared through WhatsApp. So now the legal enforcement agencies, they came down to the fact that WhatsApp has to be controlled. There must be some kind of control over WhatsApp. When they tried to approach the grievance officer of WhatsApp, it was shocking for them that that till that point of time, the application, like the service provider like WhatsApp, they had not they had not appointed formally the grievance officer for India. So it was a shocking for them. It was a shock. It was a great shock. And about WhatsApp, even if we talk about 2018, the situation was without WhatsApp, we could not even imagine our interaction with family, with our friends. Till that point of time, it was very popular. All right. So in 2018 also, it was very popular. And a popular application, a popular service provider like WhatsApp, not appointing the grievance officer was something very serious, and again pressure was created, and again to to resolve the issue, WhatsApp appointed Komal Lahiri as the grievance officer. So now the thing is, ki we were having rules till 2011. We had amended the law in 2009 after 2008 Amendment Act again, but it was not implemented. So law regulation was there, but again, one of the most important thing, the appointment of grievance officer, that was not taken into consideration. So this was handled here. So again, this is the thing which was done, that section 21W definition was broadened, due diligence was provided. Then for this, rule 3 under intermediary guidelines, rules 2011 was framed. And then one more thing was there that was related to sensitive personal information, rules 2011. So this was related to intermediaries. Now coming to the last phase with which we would be ending our interaction, that is the current issues. If we talk about the current developments, we are going through the phase of semantic web. Semantic web, by semantic is a term which is coined by Tim Berners-Lee, who invented World Wide Web. Semantic is something omnipresent. So web, internet has today become omnipresent. It is present everywhere. So we are living in that era. We are living in an era of IoT, in Internet of Things, where every appliances we are using, all home appliances, they are becoming smarter. By smartness, the smartness here is that they can be linked with internet. We online purchasing is going up. 2014, after 2014, when the current leadership came into power, again since then, Deepavali after Deepavali, festival after festival, again online purchasing is going up. And again, a big push has been received because of the crisis we are going through since 2000, COVID 2019. Then we have artificial intelligence, we have machine learning going up, and then we have Modi 1.0, where they came up with Digital India program, where the focus is to promote a digital connectivity. They many a times our Prime Minister has talked about that digital connectivity must be taken as a basic right of every individual. So you would have we have seen that again after 2014, the rate of the internet, the prices, they have gone down, and because of that, there has been this technology is becoming very popular, and the connectivity, they have come up with Digital India program with lots of pillars, where the broad connectivity, every nook and corner of the country is connected. Is they want to connect every the with a broad network. And again, with the internet, they want to transform India into a superpower. So this is their Modi 2.0, again when they again came into power. And again, the focus has remained, the focus has sustained. And again, especially because of this COVID thing, again the focus has been on the digital things. All right, so this is the thing. And again, please keeping the benefits of internet technology in the background. There are certain things which we need to focus upon if we talk about the current issues. First is the issues related with e-governance. All right. If we talk about e-governance, if we talk about the regulation aspect, so e-governance is something again where the future lies. But there are certain issues related to e-governance. If we talk about the current scenario, first of all is economic, because many a times in central government things are a bit different, but when it comes to state government, or again the levels that are below state government, here still the decisions are not that quick. All right. So again, many a times decisions are taken too late. And again, when it comes to updation of the software and hardware. About e-governance, let me tell you, e-governance is the use of ICT, use of the information communication technology. So we have to purchase. So जिस तरीके से purchasing is important, उसी तरीके से regular updation is also important. जिस तरीके से purchasing is again going for hardware, software is expensive. In the same manner, regular updation is also quite expensive. So economic issues हैं, economics, the funds are not dedicated, and again funds are not released in the timely manner. So this is a thing related to e-governance. और again इससे regulation पे भी बड़ा फर्क पड़ता है. Then we have social. social issues, language barrier is there, a gender bias is there. A language barrier की हम बात करें तो most of the data जो है, most of the information that is there, again that is not in a local language, vernacular language. तो language barrier है. Gender bias की बात है, again still things have changed, but again when it comes to buying of smartphone, there are families where again a boy would be having a much smarter phone than the girl child. And again, when everything is becoming dependent on cyberspace, and again, so your devices, your tools, your gadgets will also decide at how much you can take advantage of the online conditions. So if there will be a gender bias in purchasing of in purchasing of tools, if purchasing of devices, again this is a social barrier again which is there, and especially when this becomes more important because the way things are changing, because the way education pattern is changing. Now there should not be any bias, and every student must have access to the devices wherein they can adapt themselves, they can live, and they can take advantage of the online situations. इसके अलावा एक टेक्निकल इशू भी है रिलेटेड टू ई गवर्नेंस. अगेन रेगुलेशन का भी इसका एक बहुत बड़ा इसका एक लिंक है, दैट इज इंटरऑपरेबिलिटी. इसका अक्सर एक एग्जांपल मैं शेयर करता हूँ इन माय इंटरेक्शन. दैट इज कि फॉर एग्जांपल आपकी गाड़ी अगर अनफॉर्चुनेटली अगर आपकी गाड़ी चोरी हो गई है with the same number, uh, that vehicle, that car should not cross any toll. All right, interoperability should be of this level. कि फॉर एग्जाम्पल आपने इन दिस कंडीशन, लेट मी एक्सप्लेन यू फर्दर. आपकी गाड़ी चोरी होती है, आप एफआईआर करते हैं, ठीक है, एफआईआर करते हैं. एफआईआर करने के बाद भी अगर उसी नेम प्लेट से अगर गाड़ी आपकी कोई टोल क्रॉस कर ले, इट शुड नॉट बी पॉसिबल. द थिंग इज कि जब आप एफआईआर करते हैं तो रियल टाइम में दैट एफआईआर शुड बी शेयर्ड विद ऑल द टोल्स. So real-time data sharing can be possible only when there is interoperability. Interoperability अभी हमारी कंट्री में अभी to great extent that is not functional, that is not taking place. There are lots of overlappings, there are lots of duplications, and इसका एक जो प्रॉपर एक इंटरनेशनल जो एक फ्रेमवर्क बना हुआ है उसके हिसाब से अभी इंटरऑपरेबिलिटी पे अभी काम नहीं हुआ है. So this is something which has to be taken care. And again let me tell you that अब एक UN PAN है, UN Public Administration Network. They are with the help of Asian Development Bank, with the help of World Bank. Now they are promoting such programs where these kind of issues are taken into consideration, whether it is economic, whether it is social, or whether it is technical. Then these are some other issues. Again हम लोग फोकस तो है हमारा ई क्राइम्स को टैकल करने का, फोकस तो है हमारा ई गवर्नेंस को, ई कॉमर्स को टैकल करने का. बट अगेन थिंग्स आर क्वाइट डिस्टर्बिंग, and many a times every day people are becoming victim of cyber crimes. We are using these devices, we are using internet without knowing a responsibility. एक जो नेटिजन्स वाला एक जो रिस्पॉन्सिबल सिटीजन्स होने के जो क्राइटेरिया है, वी आर नॉट अवेयर ऑफ दैट. अगेन बच्चों को खास करके अभी जब ऑनलाइन क्लासेस हो रही हैं तो अगेन द किड्स आर आल्सो यूजिंग इंटरनेट. So many times parents they are not aware of the challenges which are there. तो इस तरीके के भी बहुत सारे इश्यूज हैं, और खास करके फेक न्यूज, ऑनलाइन रूमर्स वाले. एग्जांपल के तौर पे आप यूक्रेन और रशिया में भी जो इस समय वॉर चल रहा है, और जो ऑपरेशन गंगा जिसमें कि हम वहाँ से इंडियंस को लेके आ रहे हैं, अब उसके रिगार्डिंग कितने मिस इन्फॉर्मेशन है. वी डोंट नो व्हाट इज द रियल इन्फॉर्मेशन रिगार्डिंग दैट. जो हमारे जो ट्रेडिशनल जो हमारे जो चैनल्स हैं, अगेन द नोशन इज कि दे आर बायस्ड. अगेन when we go for the information that is shared on social media, again there also we have people those who take extreme position. So we don't know, so we have to be more responsible in this regard. and only then things can be taken in the right manner. देन वी हैव इशू रिलेटेड टू डेटा प्राइवेसी. डेटा प्राइवेसी को भी, जो कि साइबर रेगुलेशन की हम बात करें तो यहाँ पर डेटा जो रेगुलेशन है, जो प्राइवेसी, अगेन after the judgment of the Supreme Court, where privacy has been taken to be the fundamental right, again the focus has been on the data protection. But again, the way things are happening, the way things are turning, again, invasion of privacy is something, again, this is something which is happening already every day. And again, e-commerce के जो online advertisements हैं, we don't know, all right. So even through advertisements, they take our information, and we are sharing our information. We don't know how much information has to be shared. And again, the way websites they work, they use cookies. So cookies were just to make our internet surfing more comfortable, but using cookies, they are taking our information. They are getting aware of what we like, what we dislike, and according to that, the targeted advertisement is being done. So this is also an invasion of privacy. But let me tell you that whether we go for any kind of data protection, but the way things work, till until and unless and until we won't be particular about our data sharing, again, nothing can help. So the gaming industry, whatever sites we have, whatever applications we have, they are collecting excessive data. So again, in that regard, though these are the guidelines which are practiced since 1980 in Europe, but again, if we talk about India, we don't have act so far. So again, we have a personal data protection bill, but again, we don't have any such act. But again, going to the point that even we come up with the act, but till until and unless and until we won't be, we all would not be aware of the protection of our, or the importance of our data. Until then, nothing can be of any help. Then fake news की जो obscenity की जो बात है, anti-national content है, these are also some issues which are going up. So during the current situation, the current situation is that the fake news has really become a big concern. Obscenity that is going up again, and that is also a big concern. Then anti-national content is also something, because again, nation must be first for everyone. And again, and even the national leaders should also be ready for the criticism, because again, things have to be balanced. We always look towards US, we always look towards Europe, but let me tell you, they practice real democracy. Again, when there are elections, there are pros and cons. There are debates, and where they create pressure on each other. But again, but after elections, the thing is, everyone comes together, and for them, the nation is always first. So this kind of issue has to be there, but that is also related to the regulation thing. Now coming to the section, one issue was related to section 66A, wherein if any objectionable message, because of that, again, FIR could be filed, and under IT Act one could be booked. And it happened also after this, when Bal Thackeray died in Mumbai. So there were comments, and because of the comment from a girl and the like from another girl, both of them were arrested. And then we had many such issues, where we had a professor from Jadavpur University, who criticized the then West Bengal government. He was arrested because of the post he made. Then we had a cartoonist from Kanpur, and he was also arrested because of his posts and against corruption. So this manner, the section 66A was, again, it was when the matter was before the Supreme Court, it struck down section 66A, and it was declared null and void. But let me tell you, let me tell you that this is something uh, this here. The not only the regulation from the government side, there must be a self-regulation also. So these are some things. These are some issues. Again, where even the government has to be liberal in this regard, because again, if someone is in power, they have to be like they should not only accept the appreciation, they should also accept criticism also. So things have to be balanced. But on the other hand, even the netizens, even the netizens must be responsible. They should also think that there are ways of influencing. All it There are different influencers, and everything must be, on a healthy ground. So this has to be there. And again, though from time to time Supreme Court had asked the government to take steps to revise intermediary guidelines, and again in this regard, because again, telling you that nothing is possible with respect to the regulation of cyberspace if we don't, if we are not in a position to contain the intermediaries. So here also, when the Supreme Court asked the government to take steps to revise intermediary guidelines in this regard, again the certain proposals were made, and proposals were made to that they would be changing the intermediary guidelines, and this was proposed. And again, uh, uh, this was proposed, changes were proposed, and the after result was we came down to this 2021, the development that took place in the last year. New notification is out. The Information Technology Guidelines for Intermediaries and Digital Media Ethics Code Rules 2021 are out now. Every intermediary shall periodically inform its users at least once every year. Earlier it was कि जब हम किसी कहीं का सब्सक्रिप्शन लेते थे या कहीं अपना अकाउंट बनाते थे, only then they had to inform us. अब क्या है कि every year intermediary would be informing its users that you have to abide by the guidelines that are there. इसके अलावा earlier it was only for 90 days investigation purpose के लिए उनको information को associated records को preserve करके रखना होता था. Now it is for 180 days, and or for such longer period as may be required by the court or by the government agencies who are lawfully authorized. 180 डेज से ज्यादा भी आपको रखना पड़ सकता है अगर if it is required by the court or by the government agencies. Then grievance officer shall also acknowledge the complaint within 24 hours and resolve it within 15 days from its receipt. So again, this is the thing. Earlier it was 30 days, now it is 15 days. And intermediaries shall remove or disable access within 24 hours of receipt or complaints of contents that exposes the private areas of individuals, show such individuals in full or partial nudity or in sexual act or is in nature of impersonation, including morphed images. Such a complaint can be filed either by the individual or by any other person on his or her behalf. तो ग्रीवेंस ऑफिसर को भी थोड़ा सा और जो है यहाँ पर इंस्ट्रक्शंस मिल गए हैं अंडर द न्यू रूल्स ऑफ 2021. इसके अलावा दे हैव टू अपॉइंट चीफ कंप्लायंस ऑफिसर, दे हैव टू अपॉइंट अ नोडल कॉन्टैक्ट पर्सन, a resident grievance officer, all of whom should be resident in India. They would also need to publish a monthly compliance report mentioning the details of complaints received and action taken on the complaints, as well as details of contents removed proactively. So current जो latest जो development है regarding the regulation of cyberspace, these are those rules of 2021. और यहाँ पर भी आपको जो impression जो मैं देना चाहता हूँ वो यही है कि the whole focus is on creating pressure on the intermediaries, क्योंकि intermediaries को ही कंटेन करके को कंट्रोल करके ही आप साइबर स्पेस को रेगुलेट कर सकते हैं. दिस इज अ रियलिटी. Without regulating intermediaries, we cannot imagine the regulation of cyberspace, because ultimately everything is in their hands. wherever regulation has been successful, wherever it has been, everything is right, everything is in the right direction, it is because of the support given by the intermediaries. ठीक है. हर intermediary, every intermediary supports the issue of controlling child pornography. So efforts have been made, government has been successful in containing the child content material. But again, wherever we haven't received, wherever the intermediaries don't support, they don't come up, again in that situation it becomes very difficult for the government to take care. इसके अलावा there are many other issues also, like IPR issues are there, crime investigation is there, then violation of constitutional values जैसे ऑनलाइन स्ट्रीमिंग साइट्स होती हैं. तो अगेन ये भी चीजें हैं. अगेन दिस इज अनदर aspect of regulation, but again this is also a part and parcel of the whole cyber regulation. और जहां तक jurisdiction की बात है, jurisdiction, I told you that jurisdiction can be fixed, but investigation is something which is very difficult. और यहाँ पे मैं केवल एक एग्जांपल आपको दूंगा, अपनी बात खत्म करता हूँ, कि जो म्यूचुअल लीगल असिस्टेंस ट्रीटीज होती है ना, if we have, only then investigation is possible, first. और दूसरा, when we have mutual legal assistance treaty, then also we require lots of time. मैं केवल इंडो यूएस एमलेट की बात करता हूँ. इंडो यूएस एमलेट में भी म्यूचुअल लीगल असिस्टेंस ट्रीटी होने के बावजूद भी, जो इंडो यूएस में जो कभी जब इन्वेस्टिगेशन होना होता है तो इट रिक्वायर्स 10 months, एवरेज टाइम इज 10 months. तो 10 months का लेकिन लंबा टाइम पीरियड, अगेन we can understand that how difficult it would be to again fix anyone's responsibility. 10 महीने में तो बहुत चीजें चेंज हो जाती हैं, और खासकर अगर टेक्नोलॉजी से जुड़ी हुई चीजें हैं. So these are certain issues, and in this regard, my some points are that the ambiguity, which wherever it is there, it has to be removed. Then there must be equity in internet governance. So internet now everyone is using. So internet का जो governance है, internet the players, जो internet का जो backend में जो governance है, उसमें every country must have say. तो equity होगी, only then we can be in a better position to take care of our own interest. Then regular changes are required. 2000 में changes, 2000 में एक्ट आया था, 2008 में ही मेजर चेंजेस किए गए, बाद में फिर रूल्स आते हैं, और अभी 2021 के रूल्स आए, अदरवाइज चेंजेस नहीं किए गए, तो इट हैज टू बी चेंज्ड. देन जनरेटिंग अवेयरनेस इज आल्सो समथिंग वी ऑल शुड contribute in generating awareness. We should again go to the society. We should come up with the outreach programs wherein during in mohallas, and again our relatives, to our friends, we should make them aware of their again this cyber realities, new realities. And implementation of law is also there, because again we can come up with new guidelines, we can come up with laws, we can amend laws, but again if they are not implemented, again they are of no use. I give you example of WhatsApp. They did not they did not appoint a grievance officer. So we had guidelines, but that was not implemented. Then standard operating procedures must be there. Standard operating procedures होंगे, SOPs होंगी, तो interoperability बढ़ जाएगी. Interoperability जैसे ही बढ़ेगी, वैसे ही regulation जो है, that will become more easy. और एक और चीज है सेल्फ रेगुलेशन. अगेन वी ऑल्सो शुड बी अ रिस्पॉन्सिबल नेटिजन. वी ऑल मस्ट बी अ रिस्पॉन्सिबल नेटिजन. वी शुड थिंक ट्वाइस before posting anything, and again we should always keep in mind whatever we post, that must be on a positive note. So this is the thing. This is that internet governance which I was talking about, where again we must have a equity. There must be equity, because there are many concerns: human rights, socio-cultural issues, economic issues, development, cyber security, legal aspects, cloud computing. So everything is there. And again, in this regard, it should not be pro to certain countries, pro to certain regions. It should be everyone must be treated equally when it comes to internet governance. Only then things can be settled in the right direction. So again, law, technology, again, the situation has been very uneven. They have always shared an uneven relationship. So again, only the regulation, only the right balance between law and technology. Through the balance, again, things can be set in the right direction. So that's it from my side. If you have anything, if you have any query, you are most welcome.
So am I audible?
Yes, okay. Thank you. It-
So with respect to the spam emails that we received, like I think that the only section that dealt with briefly was section 66A, which stands script. So
Okay.
is there any other regulation or guideline in India
Regarding
with
this, beta,
respect to it?
after actually when this was struck down, when this was declared null and void, we have only IPC provisions, beta, which could be used. Otherwise, we don't have anything under the IT Act, all it to deal with this. Though we have provisions under the IT Act to go for a civil case. Okay.
Okay.
We can go for a civil case, but as far as criminal filing a criminal case is concerned, we have to resort to IPC sections. Nothing under IT, nothing under the Chapter 11 that deals with offences.
Okay, sir. Thank you, sir.
Any other thing? Any other issue?
Um, Sir, I think Mayuri ma'am isn't there.
Okay. Hmm. If there is no other query, can we end here? We have a class from 11:30.
Yes, sir. Yes, sir.
Okay then. Good day to everyone.